Common mistakes that people make going from their 482 to their permanent residence. Now we're going to talk about mistakes both from the company's end that you need to know about and also from your visa perspective. My name is Abby from Migration Centre of Australia, and today we're going to talk about how you can get to PR, but the common mistakes that people make to avoid making them yourself. For many people, during the PR process, the major shock isn't when it comes to meeting the requirements for skills or experience. It's realizing that everything can still go wrong, even if it seems right on paper. We see this all the time. Strong candidate, stable employment, years of experience, yet the application stalls or even fails. And in some cases, it's nothing to do with the visa application because it's all to do with the employer nomination. Today, I want to walk you through some of the common mistakes that people make when going from the Subclass 482 and applying for the ENS, which is either through transition or direct entry of the Subclass 186 visa. And why understanding these early can actually help save you time later on when you're pursuing this process, so you know exactly what needs to be done. When transitioning from the Subclass 482 to the Subclass 186, the employer nomination is also a key component of your permanent residency. There are two applications that are lodged. Under the ENS, it'll be the nomination and the visa as well. The nomination needs to be approved before a visa can be approved. Now, you can also go for a 186 direct entry, which is the same process. Additional requirements, you apply for a nomination and also a visa. Even if an applicant meets all the requirements, a weak or non-compliant application can result in delays or even end up with a refusal. Immigration closely examines each application to make sure they meet the structure requirements, the minimum salary requirements, terms and conditions that are offered, the market salary rate that's being offered as part of the nomination, the role, whether it's a genuine position, does it fit within the company structure, is there a need for the company to do this? This is especially important for the direct entry stream. But as part of every 186 application, the company needs to demonstrate that it does in fact need the position and can justify supporting the position for at least 2 years if it is approved. So, mistake number one, assuming that your employer is automatically eligible. Permanent nominations have stricter requirements. You still need to demonstrate that the position is required, the business is actively trading, financial viability, and now this could have changed over the years, even if you're transitioning, so be careful when you're submitting this. Compliant with tax and superannuation obligations, and being able to justify that it can financially support the role for at least another 2 years. Now, they don't need to have these funds readily available to support the role, but be able to show that they can support the position through the recurring income that they have, or the income that they will be able to make by having an additional resource. If a business has losses on their books, unpaid bills or tax bills especially, poor compliance history, or an unclear business structure, it can cause delays in the nomination or even result in refusals. Mistake two, the nominated occupation or role that you've selected does not match the occupation that you've selected. What happens a lot of times is the criteria for that role might overlap with 1, 2, maybe 3 different jobs sometimes. But the department is strict in terms of the criteria that you need to meet. If you're selecting an occupation, majority of the roles, and we recommend 80% of the roles that you're outlining as part of that job description, should match directly with the occupation on ANZSCO. This is important because the department does not allow you to mix a variety of occupations, even if they're all on the occupation list, or if you're going down the specialist skills stream, they're on the ANZSCO groups that are allowed to be sponsored. It doesn't matter. Whatever occupation you choose, make sure 80% of the roles that you've defined in your job description match ANZSCO. Mistake 3, salaries and market rate compliance issues. So firstly, depending on the type of role you're offered, you could be offered the role for a cook, for example, that's transitioning from 482 to 186. The minimum requirements for salary before when you were sponsored may have been less. It started with $70,000, for example, when they first increased that threshold for minimum salaries. But currently it is $76,515 plus super. And every 1st July it's increased. So it might be close to $80,000 on 1st July 2026. This means you'd need $80,000 plus super to be offered as a cook, which is more likely to be the salary of a chef or maybe a senior chef. So how do you meet the market salary rate for this? So it's really important to understand the market salary rate. How do you justify the position? Does it match the salaries out in the market? Are they going to be overpaid, underpaid? Is there an award rate? If you're being paid above the award rate, why is that? Is that in line with the market again? If it is, then yes, it's certainly acceptable. Even if you're being paid below the market rate, you need to justify why. It may be due to a lack of experience, due to a lack of technical ability in a certain specialization that the employer is looking for. And they will upskill you on that, and salaries can be increased during your employment as well. Mistake 4, poorly prepared or incomplete documentation. Now this one's pretty self-explanatory, but just because the minimum requirements for attaching documents is mentioned at the end of that and you've attached what you think was relevant in terms of that application, doesn't mean that's everything they're looking for. You still need to justify the criteria, and it's important to understand the migration regulations and policies around every nomination application that's being submitted. If you're providing old information that's outdated, inconsistent information, maybe the salary being offered, you've used the same contract that was previously submitted, so the salary is incorrect. A strong nomination always needs to justify why you need that position, the structure of your business in terms of organizational charts. Sometimes we go as far as getting a group chart for the entire group of companies, if it is one, and justifying how that role will play its part in a different aspect for each of the companies if they work across multiple associated entities. And that's the level of depth you sometimes need to go into to justify a role, especially an indirect role. For example, if you've got an accountant for a group of companies or a medium-sized organization, how do you justify that? What if you've got a marketing specialist working across a group of companies? You're not just a digital marketing agency, for example. So once you understand how important each document and each argument is, because the officers need to be convinced. If it's refused here, you're going to spend thousands of dollars more to appeal this decision at the ART, the Administrative Review Tribunal. Each application to appeal, just the application cost alone, is $3,500. And maybe your visa will be affected by this. What if the visa then is refused because a nomination is refused, and without a nomination, a visa cannot be granted? Then you also need to appeal the visa application, which means thousands more. And that's the cost without any representation. Mistake 5, incorrect calculation of work experience. So if you're sponsored on a 482, firstly, you need to complete at least 2 years under a sponsored company. And once you've completed the 2 years, then you can apply to transition to the 186. And secondly, even if you've got a skill assessment and you're applying in the direct entry stream, you need to have a minimum of 3 years full-time equivalent experience. You can't just have 3 years of part-time, then you'd need 6 years of part-time, which will be equivalent to 3 years full-time. Even if it's a few days short, it means you did not meet the requirements. Mistake 6, failure to disclose any information to the department, which was either part of your sponsorship obligations as a company or as part of your visa obligations as a visa applicant. There's usually a time frame of 28 days to update the department to meet your obligations for either your sponsorship or your visa. Now, if the director changes, needs to be updated. If someone's resigned from the company that was on a visa, needs to be updated. If the company's being bought out by someone else, even if directors remain the same, the shareholding has changed. So we need to update the department. If there's any change in the role, we need to update the department. We go as far as recommending that even if you're giving a promotion and increasing a salary, or someone's going from an accountant to a senior accountant, for example, we should update the department. If you're changing your address, you've changed locations for work, for example, then you should also update the department if your company is moving locations. You're still allowed to work at different offices, that's not an issue. But if the primary address of your company that was submitted is changing, for example, the lease is ending, and that means you should update the department. Mistake 7, treating the nomination less important than the visa. So I've outlined in the examples above on how key criterias, or by missing key criterias, even as simple as the salary mentioned, can result in a refusal of your nomination application, which means the visa cannot be granted. Even if you don't meet the market salary rate criteria. Now, there's many others that you need to meet to justify the nomination application is strong. If anything is missed in this, you'll never even get to thinking about your visa because it's all linked to the nomination application. A strong nomination application really creates the way for getting your visa granted. That's why having a professional on your side to consult on any of these matters, especially involving any type of company sponsorship or nomination, is really important. There can be small criteria that are missed, and because of that, it can cost the company thousands and cost applicants their visa, or even sometimes lead to them leaving Australia and having to leave the company, which can be a great loss to the company if they've lost a good employee. It's important to prepare early. You can consult people and understand the criteria. A lot of this is also mentioned on the department's website, although the key criteria may be missing, but it provides you an understanding of what you need to prepare for. If you're going to any medium to large consultancy, they will generally have a fact sheet of some kind, allowing you to understand the process involved, along with the costs involved for the entire thing. Most of our employees that we work with for companies usually touch base 6 months before their 2 years ends on the 482. And that's a good time for them to prepare and see what they need when they're planning to lodge their permanent residence. We also provide HR with meetings whenever they want to touch base regarding any of the employees that they want to talk about. Either this is when the visa's ending for a certain employee that works for them on the 482, or it can be every 6 months or 3 months, depending on what the company prefers, but it also depends on how many employees they're sponsoring. If you're unsure whether your employer role or whether your employer meets these obligations, or if you're a company looking to sponsor anyone, reach out to us for more information. The contact details are mentioned here.